This is KatAnji Brown Jackson's Dissent. I love it. I'm not going to read the whole thing. I know it's a lot to read. I know people aren't interested in the whole thing, unfortunately. Or they download it and read it themselves. So I'm going to read the beginning and the end of hers. It's worth listening to. She says, I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who is not yet sued is an existential threat to the rule of law. It is important to recognize that the executive's bid to vanquish so-called universal injunctions is, at the bottom, a request for this court's permission to engage in unlawful behavior. When the government says, do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct, what it's actually saying is the executive wants to continue doing something that a court has determined violates the Constitution. Please allow this. That is some solicitation. With its ruling today, the majority largely grants the government's wish. But, in my view, if this country is going to persist as a nation of laws and not men, the judiciary has no choice but to deny it. Stated simply, what it means to have a system of government that is bounded by law is that everyone is constrained by the law, no exception. And for that to actually happen, courts must have the power to order everyone, including the executive, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness within which the executive has the prerogative to take or leave the law as he wishes, and where individuals who would otherwise be entitled to the law's protections become subject to the executive's whims instead. The majority cannot deny that our Constitution was designed to split the powers of a monarch between the government branches to protect the people, nor is it debatable that the role of the judiciary in our constitutional scheme is to ensure fidelity to law. But these core values are strangely absent from today's decision. Focusing on inapt comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and laws of the United States. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous, since it gives the executive the go-ahead to sometimes wield the kind of unchecked arbitrary power the founders crafted our Constitution to eradicate. The very institution our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug off and turn their backs to intermittent lawlessness. With deep disillusionment, I dissent. To hear the majority tell it, this suit raises a mind-numbingly technical query. Are universal injunctions sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act to fall within the equitable authority of Congress granted the federal courts in the Judiciary Act of 1789? But that legalese is a smokescreen. It obscures a far more basic question of enormous legal and practical significance. May a federal court in the United States of America order the executive to follow the law? To ask this question is to answer it. It's a constitution. In a constitutional republic such as ours, federal court has the power to order the executive to follow the law, and it must. She goes on. She goes on for quite a while. I mean, she goes on and on. And I'd like to say, if anybody is interested, this is incredible to read. A couple more paragraphs. I view the demise of the notion that a federal judge can order the executive to adhere to the Constitution, full stop, as a sad day for America. The majority's unpersuasive effort to justify this result makes it sadder still. It is the responsibility of each and every jurist to hold the line, but the court now requires judges to look the other way after violating the law, shamefully permitting unlawful conduct to continue unabated. Today's ruling thus surreptitiously stymies the judiciary's core duty to protect and defend constitutional rights. It does this indirectly by preventing lower courts from telling the executive that it has to stop engaging in conduct that violates the Constitution. Instead, now a court's power to prevent constitutional violations comes with an asterisk. A court can make the executive cease its unconstitutional conduct, but only with respect to the particular plaintiffs named in the lawsuit before them, leaving the executive free to violate the constitutional rights of anyone and everyone else. Make no mistake, today's ruling allows the executive to deny people's rights that the founders plainly wrote into our Constitution, so long as those individuals have not found a lawyer or asked a court in a particular manner to have their rights protected. This perverse burden shifting cannot coexist with the rule of law. In essence, the court has now shoved the lower court's judges out of the way in cases where executive action is challenged, and has gifted the executive with the prerogative of sometimes disregarding the law. As a result, the judiciary, the one institution that is solely responsible for ensuring our republic endures as a nation of laws, has put both our legal system and our system of government in grave jeopardy. She says, perhaps the degradation of our rule of law regime would happen anyway, right? But this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law, as they interpret it, will surely hasten the downfall of our governing institutions, enabling our collective demise. At the very least, I lament that the majority is so caught up in minutia of government's self-serving, finger-pointing arguments that it misses the plot. The majority forgets or ignores that, with all its defects, delays, and inconveniences, men have discovered no technique for long-preserving free government except that the executive be under the law, and that the law be made by parliamentary deliberations. Tragically, if the majority also shuns this prescient warning, even if such institutions may be destined to pass away, it is the duty of the court to be the last, not to the first, to give them up. Thank you, Justice KatAnji Brown Jackson, for that, in part, dissent. Guys, yeah, it's bad, okay? It's bad. The justices are clearly warning us. There were points in there where they said about civil suits. They were talking about civil suits in different parts of their dissents, and so hopefully this will help be a balm towards the grievous wounds that are being inflicted upon citizens of the United States by our own Supreme Court. I hope that the federal judges do what they're supposed to do and protect constitutional rights of people, and ignore the fucking Supreme Court as he's telling them to ignore them, and then let it go up to the Supreme Court again. What you gonna do? So federal judiciary, hold the line.